Going into court, in a perfect, real world, or in a perfectly real and just political/legal/economic system, there would not be many occasions where the common man would be required to appear in an administrative or a judicial forum, and certainly not without an injured party willing to swear to first-hand knowledge of the facts. Unfortunately, in a world of fictions, as it is at the present time, many are being forced, under duress and threat of arrest, to appear before any number of quasi-judicial fiction forums for any number of crimes, violations, infractions, etc. of a fictional, commercial nature. So, the task at hand in such a situation is to understand what is going on and to protect yourself as best as you are able. Critical to achieving the best results is to be perfectly clear what your goal is, and to keep our eyes on the goal amidst the physical, emotional, and intellectual turmoil that such a situation brings forth. We must understand that we can only control what is within our power to control, and that we personally cannot control the thoughts, words, or actions of another. What we can do is control our own attitudes, thoughts and actions, and the making of the record. Our posture, or the way we present ourselves, is vital. Are we able to remain as man and woman of righteousness in a world of unrighteousness? Simple, but not that easy. As to the making of the record, keep in mind that in the vast majority of occasions the record made at the lowest level is the only record subject to review at any higher level. In other words, our ability to make the record to reflect the information that is vital to our well-being, at the initial hearings, is directly proportionate to the remedy that will be available to us, in any forum, for any violations of any rights and the misapplication of laws, statutes, rules, regulations, etc. The goal is to remain in honor and to make the record. The way to make the record is to stay on point, to not be led into the myriad other matters that may arise in the heat of the moment. Knowledge is potential power. Knowledge is made into effective power in individual circumstances by effective application of that knowledge. And now, on to the specific knowledge relevant to survival and success in the commercial fiction venues for settlement of disputes, the courts. Again, it must be emphasized that this is not presented as legal advice specific to any particular individual or proceeding, but is offered as general information for educational purposes. It is up to each man or woman to determine the benefit to themselves in any specific application of any information presented in any specific manner. With freedom comes responsibility. You are responsible for your own choices and actions. Going to court, the judge either calls out your name or asks you to reveal who you are. The judge is referring to the all-caps person, legal fiction, but you are unaware of this, even though this person's name is on every piece of identification that you have ever received, every bill that has come to your home, and every legal instrument that was created on your behalf, so you admit to being that person and step into the jurisdiction of the court. So you may want to ask the man behind the bench, "Sir, may I have your name?" "Thank you, Mr. Smith," or whatever, then state into the record as you either cross the bar or upon the judge calling out your debtor's name, "I am the secured party creditor/third party intervener in respect to this matter over title to the property." The judge then reads the commercial charges and asks you to make a plea in behalf of the debtor/defendant, the fiction/ins leges. Note, if you plead guilty, you waive your rights and accept the full liability and may have to sign, consent, a confession. Having been trained all your life to acquiesce to authority figures, your willingness to sign and accept your fine/punishment without ever asking if your signature is mandatory or voluntary. If this is a criminal matter, the judge is very interested that you are well represented by a class of commercial contractors called attorneys. The judge may say, if you can't afford one will be appointed to represent you for free. Don't believe that you will be presented with a contract to sign to agree to pay for the attorney. The attorney is an officer of the court. However, you have been seduced into thinking that the attorney's first loyalty is to you, but as an officer of the court, their first and sole allegiance is to the court, not you. The attorney can promise you nothing, and that is exactly what he will help you get. Of course, if you hire or accept an attorney, you become a ward of the state, an incompetent, a lunatic of unsound mind. If compelled to plead not guilty, you still imply you're guilty but will allow the judge or show jury to decide the matter. But you have then already agreed to accept the liability and the decision of the court, and now, the stage is now set. If you go away with an attorney and he's to prepare your argument and defense, beware that he will not prepare an appropriate affidavit of the facts, or know an appropriate defense for why you are not liable for the charges against your debtor. On the day of your next court appearance, the attorney will help you argue your case. The judge may ask you questions through the attorney, and you may be called to testify. With the attorney there, you are not allowed to speak for yourself. By testifying and arguing, you will be giving substance to the controversy and to all the fictions in the courtroom. In this way, you will be admitting your guilt. This will be a slam dunk for the attorney and a slam dunk for the court system. If an attorney is forced upon you, you might ask the attorney, "Can you represent me in my private capacity?" The answer will most likely be "No, I cannot," which is admission that the attorney is only there to represent the commercial fiction your debtor. The so-called defense is for appearance only, before being found guilty, imposing a fine or handing you over to one of the biggest growth industries in America, the police state/prison system, irrespective of not being subject to the statute. Prior to going into court, one should do the CAF first, see Section 5, the private administrative process. Then at the arraignment or hearing, there are questions and statements of fact that are important to make on the record in the hearing. If you have completed the CAF for the particular matter, as the judge calls the debtor's name, you state or read into the record the appearance brief statement, see Section 6, conditional acceptance. Read me first, similar to, "Well, Your Honor, I accepted for value the prosecutor's claim and agreed to pay the fine, go to jail, etc., predicated upon proof of claim." He has failed to provide proof of claim, he has failed to state a claim upon which relief can be granted, and he has stipulated to the facts as they operate in my favor and all the evidence is before the court. I don't know what to do. What's my remedy? As indicated in Section 6, as to the CAF, there is now an agreement on the table and that's all the judge can see. He now has been placed into a ministerial capacity, not in a judicial capacity. However, in the event the judge moves forward, utilize the following original 3 magic questions, as they have been called, plus there's an additional one. Often they will attempt to evade their responsibility of answering these legitimate questions. In such a situation, one could repeat the question and/or ask if they are refusing to answer the question. Remember, you are making the record. Also, some choose to preface their questions before the court with the phrase "without dishonor," followed by the question. The intention is to establish that there is no intention to be presumed to be acting dishonorably or in a contemptuous manner. 1. Question to the magistrate or judge, "May I have your name, please?" 2. Question to the judge, "Do you have a claim against me?" 3. Question to the judge, "Do you know of anyone who has a claim against me?" Repeat the same to the prosecutor. The prosecutor really is the only one who could have a claim against you, if you were subject to the statute. 4. Question to the open court, or one could face the gallery, and ask, "Does anyone present here today have a claim against me?" 5. Statement to the judge, as it appears that there is no legitimate claim presented, there is no public business before the court. I request that the order of the court be released to me at this time so that I may be free to go. And an additional verbal question might be, will the court compel the prosecutor to produce the evidence of my liability to the statute? Understand that there are any number of ways that any particular magistrate, judge, no, they are not the same, or prosecutor may respond to these questions. Remember, your question in the CAF is your private process to obtain discovery. That does not mean that the questions are not valid, or that whatever they might say in response may only be to distract or evade. The reality in the system as it is that the agents are saying and doing all sorts of things that are beyond their lawful authority, ultra vires, if there is misapplication of the statute. It is vital that however the actors respond to you, be it silence, angry outbursts, or threats of being found in contempt, that one remains calm and on point. Do not be dragged down to their level of interaction. An example of how one could respond to such outbursts and threats is, "Excuse me, it is not my intention to be contemptuous or dishonorable. I am only trying to protect my interests here. It is important that I determine if there is a claim against me and who is responsible for bringing the claim. Do you have a claim against me?" If there is not a direct response to the question, then in effect, by their general acquiescence they are all in agreement. Some have, in response to a direct threat from the court. If you say that again, "I am going to find you in contempt and remand you to custody," have asked questions such as, what will the nature of the contempt be? Civil, criminal, or the inherent power of the court to enforce its internal policy and procedure, or is it the purpose of this court to abuse me? Or are you refusing to permit me to know if there is a legitimate claim before this court? Or are you refusing to inform me of the nature of the claim in this matter? At every opportunity, attempt to have the order of the court released to you. The above steps are new to most people reading this book. Read, study, memorize the questions, statements, etc. Prepare as best you can. Do the best you can. Learn from the past, learn from your mistakes. Proceed down the path you have chosen. If the court, judge, prosecutor, etc., misapplies the law, statute, code, etc., your only remedy is tort. And if you do not exercise that exclusive remedy, you allow them to continue to misapply their private statutes to injure and harm many others out there. Many actors in the system seem to be drunk with power and have more guts than brains. Many are willing to cut off their nose to spite their face rather than be faced with having to acknowledge any limit to their authority. whatever they might say or do under the circumstances.